The state believes that could create automatic issues of appeal if that decision is beneficial to one defendant and yet harmful to another defendant. At this point in the proceeding, the requirement that the defendants receive a fair trial is better served by consistent pretrial rulings, which would help avoid the inconsistent verdicts discussed in Zafiro. In Bruton, on the same question of law or fact. The state has gone to every effort to protect both defendants' right to a fair trial, even asking the magistrate court in this case to refrain from broadcasting the preliminary hearing. Again, separate cases absolutely means more hearings, more media coverage, and more difficulty in finding a suitable jury. Mr. Daybell has provided the court with State v. Nava, as we discussed prior to this hearing. I would point out that Nava deals primarily with Rule 8A, which governs joinder of offenses, whereas the state is asking the court to make a decision under Rule 8B, which governs joinder of defendants. Nevertheless, the state acknowledges that joinder of offenses and joinder of defendants shares a similar analysis. It's important to note that the decision in Nava hinged on whether the defendants' multiple offenses shared a common scheme or plan. In the case before the court, we aren't litigating a common scheme or plan, we are litigating a conspiracy, which is the same scheme and the same plan shared by co-conspirators. Nava is instructive in its discussion of Idaho Criminal Rule 14. At the end of the day, the defendants must have a fair trial. If the defendants believe that joinder will prejudice them at trial, they may object and present evidence to the court on those grounds. At this point in the case, the court lacks enough information to make any such decision. Even if this court did find at some point that separate trials were necessary to protect the defendant's rights, at this stage in litigation, the requirements of justice and efficiency are better served by joinder of the defendant's cases under one court with one judge. A decision to join the cases now does not preclude the court from hearing argument under Rule 14 at a later time. The defendant always has the right, both defendants have the right to make that motion at any time prior to trial.
That would be a motion to sever that you're referring to?
Yes, thank you, Your Honor. A motion to sever under Rule 14. I would, as the court noted, the defendant, Lori Daybell, has filed a notice of non-objection to the state's motion for joinder. Finally, Your Honor, I would ask the court to consider the effect of keeping the cases separate, the effect that will have on the families of Tylee and JJ. They are victims in this case as well and have a right to be present at any physical proceedings it may have. Who knows how that will play out with COVID, but it's entirely possible that we will have many of these proceedings live. None of the close family members of Tylee and JJ live in Idaho, whereas due to the fact that Tylee and JJ moved to Idaho very soon before their deaths. And I'd ask the court to consider the hardship on Tylee and JJ's brother, the Woodcock family, the Vallow family, and the Cox family in keeping these proceedings separate. Consolidating these cases creates less hearings and less travel for those victims, and as such, less hardship. In conclusion, criminal rules 8B and 13 allow this court to make a decision to join these cases. The standard for joinder, again, is that the defendants engaged in the same acts or transactions or series of acts or transactions constituting an offense. And in this case, that's heightened by the fact that they are alleged to have engaged in a conspiracy. The state believes the standards clearly met in this case. Further, the defendant's right to a fair trial are protected by Rule 14 and the possibility of a motion for severance at a later date if necessary. And as such, the state respectfully asks this court to join Chad and Lori Daybell's cases into one case.
All right. Thank you, Mr. Wood, for the argument. Mr. Pryor, argument in opposition.
Yes, Judge. Judge, I took the liberty of submitting State versus Nava to the court. I'm fully aware, and I appreciate Mr. Wood pointing out that Nava addresses 8A, but I think the analysis is the same. I think in good faith, I can't argue that the allegations, and I want to make it clear that they are allegations against Mr. Daybell and Ms. Fallow are similar in nature, and that under the prong of 8B, it applies, and the joinder does apply. The objection, Judge, that I filed talks about prejudice. Further, I appreciate that Mr. Wood recognizes that at any time in the future, I can file a motion for severance under 14 and say that trying these two folks in the same proceeding is highly prejudicial. Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. But Mr. Wood's argument, Judge, to suggest a convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? And although 8A doesn't specifically address bias, the Nava case talks briefly that there is still a prejudice or a bias, and the court can evaluate that. Now, I understand there's been an inordinate amount of publicity. Mr. Wood has pointed out examples of some of the publicity, and I've pointed out examples, and that's going to be reserved for a different date in November when we talk about venue. But the fact remains, Judge, that by linking the two of these folks together is still going to provide a modicum of prejudice. And although I have to concede that joinder, when you look straight at the rule 8A, that there is an allegation of similar facts in this case. The fact remains is what I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial. I don't think it's an effective argument for Mr. Wood to suggest that he's going to have to make more effort and he's going to have to do duplicative work in two different cases. And I'm sorry that he's going to have to engage in that. But the fact remains that
I'm a little confused on, we don't get to severance without a joinder, because right now we do have two separate proceedings before two separate courts. So I guess I don't quite follow the argument of reserving ruling on joinder and then argue severance later.
well, and that's
Actually where in all we are, you could call it severed, because we have separate proceedings, separate judges right now.
I guess my feeling, Judge, is simply this, is that if the court joins the case, you're going to require the fact that I go through the analysis and we come back and there's going to be a continued hearing. Now the court understands it. Maybe I wasn't being particularly clear. I guess from my position is I would leave the status quo, because at this point, we are going to be going back and arguing these same facts again in a severance case once again, and I'm not beating on this, Mr. Wood, please don't take it this way, but once Mr. Wood resolves some of the outstanding issues that we have yet to resolve between the two of us. I guess from my perspective is that we proceed along as we are proceeding, and if at some point there needs to be a further ruling on the joinder, at that point we can go forward and do the both of them at the same time. If the court doesn't want to do that, the court can make its ruling. And obviously, I think both of counsel and I have indicated the court there is the opportunity without further action for a motion for severance in the future, Judge. Thank you.
All right, thank you for the argument, Mr. Pryor. Mr. Wood, if you'd like to make any final rebuttal argument, you can do so.
I would just point out that the duplicative nature of work in this case, if the cases aren't joined, and the inconvenience that causes not only the state but witnesses and victims, is absolutely appropriate for the court to consider. It's one of the factors brought up in the case law presented to the court. Other than that, I have nothing else, Your Honor.
Okay, thanks, Mr. Wood. Well, counsel, I've considered the motion. I'm prepared to make a ruling at this time. As I mentioned when we started the hearing, this motion's been pending for quite some time. It was filed on September 1st, so almost 2 months ago. The concerns the state brings up as reasons to join the cases at this time I've considered, and I have to look at the two-prong analysis that's set forth in the case law and supported by the rules under Rule 8 and Rule 13 of the Idaho Criminal Rules. And the two factors I look at is, number one, under Rule 8B, is there a common scheme or plan to support the joinder that is alleged to have occurred in these two cases? And then part two is, would a joint trial of the two defendants be prejudicial, looking at joinder under 13 of trying the cases together. So as I mentioned at the outset, in the other case, which is Mrs. Daybell's case, CR 222838, there was filed a notice of non-objection, and that is part of the consideration. But looking at the first prong, I think that's easily satisfied under the allegations of the two cases. In each case, there's been a complaint filed in one. In Mr. Daybell's case here today, that's an amended criminal complaint filed on June 30th. But both cases have charges of conspiracy to commit destruction, alteration, or concealment of evidence. And in each case, or each complaint, I should say, that's pending in both cases, there's a list of overt acts that are alleged to have occurred in support of the conspiracy charges, and two separate sets of overt acts. When I review those complaints, the overt acts are identical as to both cases, and the charges themselves all relate to the common evidence the state would bring forward at trial and the common witnesses based on those conspiracy charges. So it's pretty clear that the first prong of whether or not there's a common scheme or plan is supported under Rule 8B for joinder of the offenses in this case. And then looking at whether or not the joint trial of the two defendants would be prejudicial, there was an allegation in the response that was filed that this would create additional publicity, which would prejudice the right of Mr. Daybell to a fair trial if these cases were joined. I've considered that. I've also considered the arguments of the state that having two separate courses run in two different cases with two different judges could result in separate evidentiary rulings. There could be some inconsistencies. There would be duplicative hearings. And I think quite concerning given our circumstances right now under our COVID restrictions and the difficulties we have even getting a jury trial at this point, the prospect of having two separate trials where two separate juries would have to be impaneled to try each case is concerning as well. And so when I look at all the factors and the supporting case law, I don't find that the prejudice at this point has been demonstrated that would be sufficient to prevent me from joining these cases. And so based on the analysis and consideration of the citations also provided by Mr. Wood, and also in due consideration of the new case that was cited by Mr. Pryor, the Nava case, I read through that as well. I do find the facts of that somewhat inapplicable to the issue I've got at hand. That's where a single defendant had a trial involving separate multiple victims, which were put together in a single trial. Here we've got two defendants with a single common scheme or plan that is alleged. And so upon consideration of all that, council, I am going to grant the motion to join at this time. As the parties indicated, that doesn't forego the possibility of a future motion for severance if prejudice is demonstrated by the defense in support of that motion. So clearly, Mr. Pryor, you have that opportunity going forward if you believe the prejudice would exist after we get further down the road with these cases being joined. But I am going to order the joinder of the cases. I'll grant the motion. Then, Mr. Wood, if you'd submit appropriate order, I'd appreciate that.
Yes, Your Honor, we'll prepare that order.
All right. Mr. Wood, do you have any questions regarding my ruling today?
No, Your Honor.
All right. Mr. Pryor, any questions from the defense regarding the court's ruling?
No, Judge, thank you for your consideration this morning.
All right. Thank you very much, counsel. I appreciate your preparedness this morning and your briefing and arguments. And if there's nothing further, then we'll be in recess.
Thank you,
Thank
Judge.
you.